everybody. I think we're going to go ahead and get started. My name is Maria Coppola. I'm from the FTC, and this afternoon's panel will look at the differences and similarities in approach between the US and the EC with respect to platforms. It's a great pleasure to be here and to have such tremendous panelists. I'm only moderating, but to the extent that I express views, they are my own. I'm going to very, very briefly introduce the speakers. Christina Cafara, to my right, is the head of European competition for Charles River Associates. Simon Constantine is the Director of Policy and International at the UK Competition and Markets Authority. Nick Economides is a professor at NYU Stern School of Business. Nicolas Petit is a professor at University of Liège. And I think many of you know Josh Wright, who is a university professor here. I'm being told to advance slides. These are the complicated things I can never figure out. So throughout these hearings, we are thinking about international issues. We're talking to our counterparts in foreign authorities. We are clearly engaging, consulting with experts from around the globe. But this is the only panel, at least so far, that's really dedicated to a comparative analysis. And I think that reflects a little bit the fact that it's awfully hard to have a conversation about platforms these days, and in particular, I think digital platforms, without Europe coming into the equation in some way. So we today will try very hard to go beyond the headline that Europe is the only active enforcer or Europe is overly aggressive, and try to really think about how Europe approaches these issues differently from the US and what we at the FTC might learn from that as we go through a reflection process of our own approach and tools. I ask for a little bit of tolerance because we are covering in one session what will be covered in 6 or more sessions to do the US. So we're going to try to cover cases and look at things like market definition, burden of proof, effects, et cetera. And we're also going to try and think about how Europe is reacting to the public disquiet around platforms, digital platforms. So we're going to really try to address a whole broad swath of issues. The format will be like you've seen before. Each speaker will make some initial remarks, and then we'll have Q&A. My colleagues are collecting cards with questions. Please start now. We welcome them, and we will turn to them shortly after the opening presentations. To kick off the platform, I started with maybe a somewhat controversial idea, which is that Europe tends to protect competition and platforms by keeping pathways open for new competitors, new business models, et cetera. And so I've asked each of the speakers to react to sort of that premise and their views on it and the pluses and minuses. And I'm going to start with Simon Constantine.
Thank you, Maria, and thank you to the FTC for inviting me here today. I guess I'm going to start by sort of taking my position as the regulator on the table to try and challenge some of the views, or at least the cliched statements that have sometimes heard around the debate on these issues. That said, I'll start with a bit of a cliche of my own, and the reason I use it is because it has the benefit of being true, and that's that, as regulators, we believe that the large platforms, they provide a huge amount of consumer benefit, they provide benefits for businesses, and I think you'd struggle to find a regulator that would say differently, and while that may sound like a statement of the obvious, I think it's something that does occasionally get lost when we get into debates about levels of intervention. Coming then to the cliches, I suppose, is the first is this idea of an EU approach and a wholly different US approach. While I think there are sort of differences on both sides of the channel, I think there's a multiplicity of views within Europe and within the US, and I think actually there's really, when you look beyond the headlines, quite a lot of commonality really among about some of the general principles. So that's the first. The second is what Maria just touched on, which is the idea of protecting competition rather than consumers. Again, I think that sort of accusation is rather misplaced. While it's true to say that under EU law, for example, a company in a dominant position has a responsibility not to distort open competition. That idea of keeping open competition is quite different from somehow seeking to prop up inefficient and all the more so European rivals. The effect on the consumer is really, personally, I think, at the heart of everything we do. If companies seek to distort that competitive process by excluding rivals, then that is depriving effectively consumers of the choice to choose between the models that best serve their needs. So, this sort of totem of competitors, not consumers, I think again is rather too broad. And finally, it's sometimes that same argument finds another form, which is the idea of that this is some kind of anti-Americanism. Now I can only speak for what I see and observe, but in all my dealings with people at the European Commission and elsewhere, I don't see any evidence of this. I mean, certainly the large platforms that people are looking at, they are largely American, but I mean, I think to turn this into a debate about the nationality of any particular company rather ignores the sort of genuine questions that are being asked throughout the world, and publicly as well as in antitrust circles about for all their benefits, what are the longer-term effects and implications on consumers of some of these large platforms. Those discussions, which we're having now about platforms, we equally have about our energy companies, our banks, our grocery stores, none of whom, in the UK at least, are American, really. These are all EU and UK businesses. So I think to bring it down to some principle of nationality is a bit simplistic. So then, as Maria said, sort of broadening it out a bit and sort of thinking about, what's the role for antitrust then in these areas. I think it's right to say that antitrust shouldn't make up for failings in other laws. So whether it be data protection law or consumer protection law, if there are issues with those laws, then I think your starting point should be to address those issues rather than somehow seeking to extend antitrust law to areas where it shouldn't really tread, as it were. But I don't think that's the same as sort of saying somehow that antitrust should just step back entirely, or that when you're looking at issues of data and privacy, that antitrust law is somehow completely irrelevant. Competition issues aren't relevant. I mean, on the one hand, it's quite possible, and indeed one might hope, that the level of privacy protection that a company offers might be a metric on which it seeks to compete. Similarly, you can envisage a situation in which a company might use its acquired data or the data it sort of gathers from consumers to either increase barriers to entry or to potentially exploit consumers who are less able to switch than others, for example. And to me, it seems like these are absolutely the areas for antitrust to be considering. So then you come on to the question of, well, are the laws sort of right for dealing with the problem if there is an antitrust question here? I think we heard it earlier from Randy, who was saying, you know, at heart, the broad principles, when you apply them to the facts, very robust and flexible. I think that's quite different from saying that we shouldn't ask ourselves some pretty tough questions about whether laws are in need of some kind of refresh here. But I do think that the underlying principles have proven to be quite successful. And then you come on to the final part, and I'll just touch on this briefly before wrapping up, is looking at what the role of regulation is here. I and my colleagues, I think we remain of the view that competition generally remains the best way of driving beneficial long-term outcomes for consumers. But I think when you look at regulation, to borrow the terminology of our chief executive, I think we have to take more of an agnostic approach, I think, to whether regulation may, in certain circumstances, actually drive better outcomes for consumers than ex post enforcement. There may be areas where sort of traditional competition or open competition in a market may not drive really well-functioning markets, or the law may not stretch and extend so well. One might look, for example, at asymmetries in bargaining power between companies, circumstances which, if it were between a consumer and a business, might be considered unfair between a large platform and a small to medium business. You know, do we need laws to cover those? Now, the antitrust laws themselves don't necessarily go there. You might, on occasion, need regulation. In the UK, for example, in the grocery sector, we've seen specific regulation to address that market failure. So I think that while obviously any regulation should be targeted, proportionate, especially designed to ensure that it doesn't somehow sort of fossilize incumbency or impose excessive burdens on small players rather than the large ones. I think that even with those caveats, I think one can definitely see here that it may well be through a blended approach of both regulation and effective enforcement of the antitrust laws that we might get to the best outcome for the consumers.
Thanks, Simon, including to remind us about all we do have in common. And I think I may have focused a little bit more on the differences, forgetting that the vast majority of areas we are very much aligned. I'd like to hear from Nicolas.
Thank you, Maria. And thanks to the FTC for the invitation and more generally for reaching out to the global antitrust community and beyond to talk about those hugely important issues. So I really want to make 3 points. The first one is that it is wrong to search guidance in European competition policy for sort of antitrust hipster or new Brandeis counter-revolution. So some in the US talk a lot about structural dominance, or they suggest when they talk about that, you know, we have a sort of tradition of ordoliberalism that can provide guidance. This is not serious. In unilateral conduct cases, we have some case law which suggests that indeed dominant firms have a special responsibility not to impede competition. That case law subjects dominant firms to very strict constraints, asymmetrical behavioral obligations. But the problem is that this case law has sort of been recasted by the European Courts of Justice last year in the judgment in Intel, where it's explicitly said that an empirical assessment of economic effects should guide the analysis of anti-competitive conduct. So that's really the sort of, you know, first cliche that I wanted to debunk here, which is that there's no such thing as a sort of ordoliberal thinking in European competition policy, and there's nothing to see there if you want to think about the future of US antitrust. The second point that I really want to make is that European competition policy can be better described as a sort of experimentalist policy rather than a structuralist policy in the tech sector. And the high-level idea is that European competition law is less risk-averse in situations of uncertainty. So antitrust cases can be started in situations of imperfect information, emergent behavior, and unclear judicial precedents. This sometimes leads the European Commission to adopt a precautionary approach to antitrust policy, especially in abuse of dominance cases. A member on the other panel, Doug Melamed, said a more probabilistic approach to antitrust enforcement, and we really can see that. And that actually owes to a range of sort of endogenous European idiosyncrasies. Just to run you through a few of them, the standards of evidence that we have in conduct cases are quite flexible. The case law does not require proof of actual anti-competitive effects. There's less reliance on quantifiable estimation of harm. Plaintiffs must generally show capability of anti-competitive effects. The standard that we apply is a totality of the circumstances standard to evidence. Another factor which could sort of mislead external observers in thinking about European competition policy is that there is probably less faith in Europe in the tendency of markets to self-correct, and probably more trust in government, in the ability of government to correct and improve market outcomes. That means that the agencies are actually looking at type 1 and type 2 errors, maybe in a more balanced way than the agencies or plaintiffs look at them here in the US. Judicial review is less intensive over economic assessments. We have sort of, well, maybe I'm just mischaracterizing US law, but we have a sort of Chevron deference in the area of antitrust in the EU, and that also has a lot of impact on how the agencies can feel confident or not in bringing those complicated cases against large corporations. And maybe last but not least, distributional choices are more legitimate or easy to sort of think about in antitrust in Europe. Remember that Article 102, our equivalent to Section 2, talks about the ability of dominant firms to unlawfully charge excessive prices on buyers. So we have all those features in the design of our system which make it that maybe our antitrust policy is more experimental and maybe more confident in going after cases in which there's a lot of uncertainty. So now really to the core of your question about trying to characterize the European tech policy in the platforms world, I think there's really four important policy messages to extract. And again, that's really sort of bird's eye view because there's no sort of clear and formulated message in policy talking. Message number one, tech policy is essentially to be addressed through ex-ante regulation. GDPR is the obvious case, but that's not all. I mean, platform cases in Europe, they're often followed or seconded by regulatory propositions, and they seem to sort of position antitrust enforcement as a fact-finding exercise or as a regulatory Kickstarter, like putting pressure on regulators to think about bigger solutions. So you can think about illustrations. I mean, proposals to introduce a general platform regulation in tech to ensure sort of rights of redress to developers and trust and transparency. The tax on revenues from digital activities, initiatives taken in the area of copyrights. So all those things sort of show that there's a sort of big regulatory campaign in the area of tech, and we should not surely miss that. Message number two, the long game of the European tech policy seems to be, so again, this is not really explicit, but it seems to be to protect players active in the content development segment of the markets. I'm thinking here about artists, publishers, developers, vendors, and so on and so forth. And again, this can be seen if you combine platform adverse antitrust enforcement initiatives together with all sorts of regulatory proposals, net neutrality, copyright reform, online platform regulation. You can tie this to sort of political economy considerations. Remember, we hear a lot when in the US that Europe has no tech companies. The two main tech power players in Europe are sort of more in the content segment of the market. You're talking about Spotify and Deezer. The publishing industry has a lot of clout in Brussels. So, if you think about tech policy, I'd say think about content. That's probably where there is a lot of action. Message number 3, trust matters. Tech platforms must honor the trust placed by third parties in them. And if not, they might risk antitrust exposure. The two Google cases, shopping and Android, that we have seen in the past 3 years really show that, or sort of tend to imply that it's bad for Google to rig internet search results and not provide search results that users are expecting to have based on relevance only. And Google Android has a bit of that spin as well, where policy messages have been made that Google was not really selling an open source operating system, and that was wrong. So the fourth message, and I'll close here, and that ties to the previous discussion in the previous panel. It seems fair to say that the European Commission puts emphasis on intra-platform competition, maybe more than inter-platform competition. And so this is very clear in the shopping case. It's really about protecting comparison shopping websites. It's a little less clear in the Android case, because there are some saying in the press release that the European Commission is also trying to protect competition in search engines. Not too sure about that, but clearly an emphasis on intra-platform competition. Thank you.
Thanks very much, Nicolas. I note that there's a lot of different interpretations of Intel, and I applaud yours, but note that it's one of many and has been a source of controversy, at least it seems so, among the enforcers. I'm also glad that you referenced the previous panel. I don't know about others, but when I was listening, it sounded very much like they were talking about European competition law today when they were talking about Microsoft. And that was a really kind of interesting perspective. And finally, on the point of ex-ante regulation, I hope that you and others will weigh in a little bit today on the proposed platform regulation in Europe. Okay, so now we have Nick, who I think is going to do a deep dive into a recent case.
Well, thank you very much. Okay, so I'll talk about dominance and tying in the Android case in the European Union. Just to be sure that we are on the same page, the Android operating system is an off-the-shelf operating system that an OEM can freely install on a cell phone or other computing devices. And Google Mobile Services is a collection or a bundle of applications including Google Play, Google Search, Google Chrome, and others. And all these applications, of course, are complementary to the Android. And there are a number of third-party apps competing with the apps of GMS. Google Play is a crucial application, very desirable to manufacturers because it's an application that allows search, purchase, download, update, and so on. Essentially what Google offered to the OEMs is to choose whether or not to install the whole collection of GMS. So if the OEM installs GMS, Google's contract obligates the OEM to pre-install all the apps in the GMS bundle. Therefore, Google Play is contractually tied to other apps in GMS, including Google Search and Chrome. Additionally, Google wants the OEM to pre-install Google Search as a default search engine if it accepts GMS, and also to pre-install Chrome. Additionally, an additional requirement is not to pre-install apps that compete with GMS apps in any other device. So if I'm Samsung and I make 25 devices and I accept GMS in one, I have to accept it in all and not install competing apps to GMS in any of the 25 devices. So the European Union complaint came in April 16. It's what Americans would call abuse of dominance. There was a similar complaint in Russia. And among other facts there, besides the very big market shares of Google Play, Google Search, and GMS, is the fact that Google paid OEMs to exclusively pre-install Google Search under the condition that no third-party search other third-party search could be pre-installed. Okay, so it appears that Google's strategy is to protect and strengthen Google's dominant position in the general internet search and adversely affect competition in the market for mobile browsers. The European Union wrote in the complaint that, in their opinion, the anti-fragmentation agreement, which was to not pre-install apps that compete with GMS apps, is not objectively justified. And there is some outside research that says that Google pays $12.85 per phone to Apple to make Google the search default. Now, is there harm? What are the allegations of harm? First, that consumers are harmed because they have less choice in browsers and search in general. That there is going to be less third-party entry into apps so that innovation is harmed. That competition is harmed because of fewer third-party apps. And again, in American terms, we would be saying something very similar to the allegation against Microsoft that the bundling GMS strategy preserved and enhanced the dominance of Google search. Okay, so what are the theorems of harm that were proposed by the European Union? Theory one, that Google is better off and search rivals are worse off under tying. Consumers and competitions are harmed through tying. Theory two, consumers are harmed because tying left them with less choice. Theory three, innovation was harmed since fewer third-party apps were developed. Theory four, tying of Google search with the very desirable, as we said before, Google Play, is used to enhance and preserve the monopoly of Google search. So in some way, this case is similar to Microsoft. The dominant company, Google, forces acceptance of Google search through tying with Google Play, similar to Microsoft tying media player with the operating system in Europe. Additionally, dominant company Google enhances and preserves the monopoly in search through tying, very similar to the Microsoft case of Internet Explorer tied with the operating system. What have been Google's defenses? One, that consumers can easily download other browsers, so the default doesn't have a lasting effect. This is, in my opinion, a factual or empirically testable hypothesis that can be proven or disproven. The second defense of Google has been that the present world is the only way to make money in this ecosystem. Again, this is testable, in my opinion, unlikely, because Google has been very successful in PCs in search without tying to anything. The third defense is that the OEM has the option not to install GMS, which is true, but not relevant because the tying happens once GMS is installed, and therefore, what happens when GMS is not installed is totally irrelevant. Okay, so what happened in the case, the EU fined Google 4.3 billion euros in July 18, and the main 3 points that the European Union underlined in its press release, and we have not, unfortunately, seen publicly the whole decision. The 3 points were, one, that Google has required manufacturers to pre-install Google Search, app and browser, parenthesis Chrome, as a condition for licensing Google's App Store, the so-called Play Store, one. Two, made payments to large manufacturers of mobile networks to condition and exclusively pre-install Google search in their devices. And number 3, it prevented manufacturers wishing to pre-install Google apps from selling even a single smart mobile device running an alternative version of Android that was not approved by Google, so-called Android forks. Okay, so remedies, the most likely or minimum remedies are going to be that Google will have to untie the Play from Google search and the Chrome browser. Second, that Google has to stop paying OEMs for exclusivity, and there is some evidence that Google has already stopped doing that. And 3, Google can no longer stop an OEM from selling devices with Android forks, even if the OEM uses Play in some devices. So this is more or less where we are. Today, Google has also announced that it has announced remedies like the ones I just mentioned, and it has said that it will start charging for use of Google Play. So at the end of this picture, after looking at this, one gets the feeling that Google has snookered the regulators, especially the US regulators. The US seem to have dropped the ball on this issue. Essentially, Google used an illegal tying tactic to increase its market share to the detriment of consumers and rivals for many years. It's very possible that this will have lasting effects on search, and the remedies that I have discussed before do not take care of that. And it's kind of an open question whether there should be additional remedies. Thank you.
Thank you, Nick, and I'm glad that you had a chance to have a quick look at the remedies that just came out today. Next, we'll hear from Josh Wright. Josh?
Thank you, and I wanted to co-sign with my colleagues who have thanked the FTC for putting this on, and I'm especially grateful that it is here at George Mason, and I know I speak for the law school and the GAI in saying we're sort of pleased to be participating in this debate. So platforms, for a variety of reasons, and I think spelled out by my colleagues on the panel, a fun and hot and even maybe for antitrust terms anyway, a sexy topic in antitrust. My job for the next 7.5 minutes, I think, is going to be to make the point that the differences that we really see in US and European antitrust treatment in Article 102 and Section 2 have little, if anything, to do with platforminess, I think was a word frequently invoked yesterday. I really don't think the panels have much to do with specific differences about platforms, so in some ways my goal for the next 6 minutes is to make the topic far less sexy than it sounds, but I think I can probably get the job done. I do think, and I'm glad that Simon started with the proposition that there really are much more in the way of similarities here than differences. I think that's an important place to start, whether it is methodologically on basic principles of market definition or at least a statement that we are all doing the consumer welfare standard. I think now more or less everybody says that. But I think sort of a layer beneath the observation that we're sort of interested in harm to competition and effects and doing consumer welfare, there are some important, I think I will use the term methodological differences that one can see, sort of stylized empirical regularities and decisions involving single firm conduct that come out of the EU and the US that I think are interesting and important for discussion. Some have already been raised. Nicola raised the sort of emphasis on intra versus inter-platform. I think the idea, the importance of the role of judicial review as an institution in single firm conduct cases is obviously, I think, incredibly important to determining how regulators and courts behave sort of in the first instance. But I think those subtle distinctions in the way we talk about how to analyze single firm conduct cases are tremendously important. I just don't think they come from platforms. And it is true that there are unique features of platforms that end up being important in cases, right? We get, and we have that in US law in some places, whether one reads Amex that way, or the DC Circuit's interpretation of Jefferson Parish's tying test for sort of integration of what would be separate parts. This is not to say that platforms don't have sort of fun, unique, special features for antitrust analysis, but I think the difference is that we observe in the types of cases that people are mentioning. So whether it's Google or Intel or what have you, are really the same fundamental Section 2. I remember way back when it was the Section 2 Article 82 debate over divergence between the US and EU on single firm conduct. And there are a whole host of possible explanations for those differences. I think Nicola mentioned some of these in his talk. These are sort of the standard menu of items for possible differences, different priors with respect to how frequently tying or vertical integration or exclusive dealing is anti-competitive. Those are topics upon which economists, I think, have quite a bit to say. Differences, whether ideological or cultural or political or economic, on how one weights type 1 versus type 2 errors. I think all of those are important. I will focus just on one difference that I think is important to invoke in these sorts of conversations, and that is sort of a fundamental question on when it is appropriate or optimal in the design of antitrust standards, keeping open the idea that the optimal standard might be different in different countries in different settings, but when it makes sense to infer harm to competition from harm to a rival. That is, in large part, my read of European decisions is a greater propensity to infer harm to competition from harm to a rival. That has a place in U.S. law and in sort of U.S. agency jurisprudence as well. But sort of more and more likely, U.S. agencies and courts are to demand evidence of actual effects as opposed to inferring likely effects from harm that can be demonstrated to a rival. I think I've got 2 minutes to go, maybe 2.5, so I will. I did not plan on doing this, but Nicholas said snookered, and that got my attention. So I left the FTC. I did not participate in the Google case. I came a couple days after it closed, maybe coincidentally. But I do object. I think we said we would sort of make an effort to escape from cliche treatment of cases, and I think the idea that the FTC got snookered or captured or some such is a cliche that deserves to be abandoned. At the agency, I think I set the record for dissents over a 7-year term in 3 years. I can tell you it's really hard to get 5-0 decisions. I tried to ruin lots of 5-0 decisions. It's very difficult to do. That is a 5-0 decision, and I think the agency statement, which talks in part, by my light's not enough. I sure wish, this is the case where the agency accidentally released a half page of the Bureau of Competition memo. The one to let go of, and I've said this in public before, the Bureau of Economics memo that actually shows the work that the agency did. I think John Yoon is not in the room, but my colleague here, John Yoon, who was the staff economist on that case, it's a paper, it's up on SSRN, obviously can't talk about what the staff did in that paper because the data are confidential, but for those actually interested in what the agency did in the case, I think it starts with reading that paper and the FTC's closing statement. And the FTC makes clear that what they relied on was they took the theories of harm seriously, they tested them against data and looked for actual effects, and they found the evidence lacking using real economic evidence. Now, could be the answer is you get a different result in Europe than the US. I'm sort of open to that. You could very well run sophisticated analyses in both places and come to different answers. I think that's a possibility. But I think we ought to take the agency for its word and what it describes, sort of what it did in those cases. So that, I think, gets us a little bit closer actually talking about what the standard of competitive harm is, what evidence is sufficient to substantiate claims that there is harm to competition, when is harm to a rival without showing an actual effect on competition sufficient to substantiate such a claim. There are lots of different views there. some which I think can be resolved, some that can't. But I think talking about the work that the agency actually did, rather than talking about whether or not it was snookered, is probably a more fruitful avenue.
Thanks, Josh, and thanks for reminding us, too, that we want to be thinking to the extent that we can about platforms as opposed to simply single firm conduct. I think now I'll turn to Christina.
Thank you. And again, my thanks to you and to the FTC for the privilege of being here today. I will touch inevitably on multiple themes that have been already touched upon by other panelists. I'd like to give you a sense for really what it is that may be different in Europe at the moment, where the narrative is and where the conversation is going. With the proviso, I agree with Josh and others that we have a lot in common, and any differences is not specific to particularly to digital platforms. It is also true, though, that in the current debate about enforcement around digital platforms, these differences are becoming amplified, and the discussion inevitably turns also around them quite a lot. In the spirit of disclosure, I work, of course, with Charles River. I have, in the past, advised third parties in the Microsoft case in Europe. I have been involved for third parties also in the Google Shopping and Android case, but of course what I'm going to say here is entirely my view and does not in any way represent that of other CRA colleagues. I need to say that. I also need to say that although we will talk about Europe, this is obviously a shortcut. Inevitably, when we talk about Europe, DG Competition and the European Commission are the center stage, but it is important also to bear in mind that there is a very diverse and lively broader environment of agencies at the national level that are very active in this space. Simon represents the UK, we have the French authority, the German authority, very influential, the Italians. So there is, in fact, a broader narrative and a broader picture out there, which will collapse a little bit into simplification when we talk about Europe as a single entity. Now, with that said, I think I would also like to start with perhaps what is not necessarily a caricature, but it is a description of what the European position in these kind of cases is often described as in conferences and in debates around policy. There is a sort of a description that essentially goes, Europe is mainly protecting competitors rather than, that is the goal of competition enforcement. We're protecting competitors rather than anything else, rather than the consumer welfare. We're pursuing fairness as an enforcement goal as opposed to a more legitimate one of consumer welfare again. And we have a host of other policy objectives like the digital single market. Nicola hinted at some sort of content support for local content, which may be bundled up in some of the antitrust cases. And finally, there is also this thread, this sentiment that there is a tech envy in Europe. We don't have our own Googles. We don't have our own Silicon Valley. We don't really produce these tech giants for a host of reasons. There was an interesting article in The Economist last week that explained the history. We don't have unicorns in continental Europe at the moment. There are a couple in the UK, but nothing to challenge the US Chinese sort of supremacy. So all of that is the kind of narrative that is often sort of put forward in these kind of discussions. I want to pick up on a couple of misconceptions, and this is my first point. The first one is really this notion that somehow Europe is pursuing some other goal, some protection of competitors as opposed to consumer welfare. I think that is simply not true. Nor is it true that in cases like Google or Android, there has been a protection of competitors in preference of a notion of consumer welfare. It has been mentioned before, there is no question that in Europe we have a special responsibility which is allocated in a dominant company to not undermine competition. But the notion of consumer welfare is very central to what Europeans do and how they think about it. It's only a notion of consumer welfare, which is not narrowly focused on output and price. That discussion about the boundaries of consumer welfare that sometimes one sort of sees here seems puzzling to us, because for us, consumer welfare is very centrally price, output, choice, and innovation. And I hear Josh when he says it is very difficult to infer consumer harm from harm to a rival. I realize this is a discussion which is at the core of this, but if I think about what the previous panel discussed, I mean, Doug Melamed talked about the Microsoft case and very clearly said, we took the view that in a probabilistic sense, markets in which you have more competition, more active competition, tend to favor more innovation rather than markets which are set around a very strong monopoly or a dominant firm. And this is not a novel view. This is a view we had absolutely pursued back in Europe at the time of the Microsoft case. There was a big debate at the time from Microsoft, and I'm talking about the server case, about we're being expropriated by intervention. Our intellectual property is being expropriated. There will be a reduction in our incentive to innovate, to which the response was, what about the overall incentive to innovate? What about the implications for competition and the overall effect on innovation in its totality? So I think that it is fair to say that we do not see any abuse around the introduction of an innovation. There is no notion of an exclusionary innovation. There is a notion that what is problematic is conduct around innovation that may be tilting the playing field. And certainly in Google shopping, the concern was the discriminatory sort of way in which some of the new features of the product appear to have been introduced. This is the objection that really carried weight in Europe. So this is the first I think, misconception that needs to be cleared up. We certainly pursue consumer welfare, and we see innovation as being central to that. The second misconception is that somehow we don't know our economics in Europe. We're a little bit fluffy. We do this kind of theories of harm that are a little fluffy, and we don't really do them in a tight way. We need to go back to school. Well, this isn't so, because although there may be some question around some of these theories, I think that it is absolutely clear that any one of the concerns that have been pursued in these cases has been and can be expressed in a very standard Chicago-type model, dotting all the I's and crossing all the T's. There's been a lot of academic work supporting, for example, in the Android case, notions of dynamic exclusion, dynamic foreclosure. There are models that show static foreclosure. So I think this is also sort of some notion that we do things because we like strange ideas like self-preferencing is a caricature of how things are in Europe. Next point, and I'll try and be brief, is of course this doesn't mean that the tool that we use has no limitations. There are significant limitations, particularly I'm thinking about Article 102 to pursue conduct in the case of dominant firm. One, and it will appear surprising to some of you perhaps in light of the previous discussion on the Microsoft case, is in fact the Microsoft legacy in Europe. And when I say that, it is very much the Microsoft server case that I'm talking about. The reason is that, good as that case absolutely was, it has embedded and established a precedent which is the one that everyone in Europe, or certainly the European Commission, is very favorable to. The notion that you build an anti-competitive story around leveraging and around time. And so every single one of these stories ends up being fashioned as a time story. And now, this may well have merit in the case of Android, and I think it does. In the case of shopping, I think it's a bit of forcing the discussion to describe that as a tie. I don't see that as a tie. This time it's a vertical foreclosure case. But what it means is that it may be a bit of a straitjacket when we think about cases, because it means that everything needs to be fashioned in that way. Things don't get off the ground if they don't have that structure, and that doesn't capture the totality of the cases that we may be worried about, or the totality of the circumstances that we may sort of face. Second limitation, which I think is very, very clear, is the nature of remedies. In these cases, we pursue a theory of harm, but how effective are really the remedies that we're able to put in place? And there is a variety of reasons why these remedies don't seem to be doing very well. I mean, effectively, you say to a dominant company, off you go, cease and desist, and come up with something better. And in part, it is the asymmetry of information between the regulator and the company. There is very little ability to really drive what's going to be adopted. So I don't think it's a surprise that the shopping case is delivering absolutely nothing. It is generated a sort of an auction type mechanism with all good intention, but no one, there is a monitoring process going on, but I think there is great skepticism that this is doing anything particularly worthwhile. And I think it's a recognition on all sides. So what is the purpose of these cases once we find a theory of harm if we really cannot put in place a solution that makes a great deal of sense? And I have to say, we'll see how it will play out, but of course, there is a possibility that Android will also sort of remain in that kind of space. Do I have another couple of minutes?
Yes.
Okay, so the third point I'd like to make is that, okay, so these are the limitations of the tool, and we know them, and we understand them. At the same time, I think it's very important to understand also the kind of observation that Europeans are making, European regulators and European observers. What is clear, or what appears to us, is that all this kind of awesome digital world that we were expecting was going to unfold sort of before us, in which there was going to be leapfrogging every 5 minutes, people were multi-homing, people are just totally downloading frictionlessly without any problem, is not kind of happening. And there is a great deal of concentration in terms of bottlenecks and channels of attention into limited, very big giants. And that is a question that we're putting ourselves. Why do we observe this? Why aren't we observing this kind of much multifarious, multi-wonderful world of changes? So that's an open question. Another question is the fact that we observe acquisitions going on all the time, buying other small companies, and that may well be very legitimate, but there is also this question of these killer acquisitions. Its papers are around looking at this. There's the question of extending the position in multiple adjacent markets, which is absolutely the heart of the digital economy. Combining complements is the thing, but what's the line between that and some form of occupying a space or foreclosure? The one monopoly profit theory doesn't necessarily work that well when you have a zero price constraint. And the big question, and I'll end on that, is really what do we know about the effects of all of this on the rate of innovation? This is the question that empirically we don't have a good handle on, and it is, to me, at the absolute core of all of this. Do we know whether in all of this we see innovation sort of thriving on the shoulders of giants, or do we see it wilting in the shadow of giants? There is very little that is actually done in this. I see incipient studies. There is something which I've seen recently that sort of looks at the rate of VC investment in startups and looks at specific segment, so internet retailing, internet search, and social networks, and would appear to suggest that the startup VC investment in new companies in these segments has gone down in recent years. If you take that literally, that would appear to suggest that there is perhaps not so much benefit to small companies innovating in the shadow of giants because there is not much funding, and whether that is because there is a fear of expropriation is unclear. But of course, we need to look at funding for complements as well as substitutes. So to say, this is absolutely the core question, which should be, because more research is needed, but it is one that we should absolutely pursue if we are going to be shaping the tools, and I'll go to the tools later, in a way that is meaningful in the future.
Thank you, Christina. I have about 100 questions, but before I start, and I have a few from the audience as well, did any of the panelists want to comment on any of the opening presentations? No, okay. Well, I suppose I have one very quick question and then a series of longer questions. The first one is, I think, a lot of what we're talking about here is harm, and what do we mean by harm, and the link to the consumer welfare standard. Christina, you talked about something that was a little intriguing. You said conduct that's harmful, but it doesn't neatly fit into the Microsoft tying or bundling. Just briefly, what type of thing did you have in mind?
Well, I'm just saying that if you think, it's important that we think about the concerns that we might have. What are we seeing, and how does that may look like a competition problem? In Europe, the problem is that you are then having to try and fit that into the boxes of tying, and not everything is a tie. That's the point. So if you think about the concerns of, for example, publishers that Nicola mentioned, there isn't a tie, there is a concern about traffic allocation, and that might drive the choice of business model in a way that perhaps doesn't fit with the underlying preferences of consumers, but reflect the preferences of the allocator. So how do you fashion that into a theory of harm? It's not a tie, no one's tying anything with anything. So I'm saying that, that's one limitation that I see in Europe, in the ability to actually be effective in designing a theory of harm
Right.
that will get traction.
We can think about whether some of these issues are better addressed by regulation in a minute. I just wanted to turn to Josh, actually. Christina had suggested that the Europeans think about consumer welfare, but they include not just price and output, but also choice and innovation. I suppose there was sort of a subtext there that maybe the U.S. Antitrust authorities aren't thinking as much about those. Did you want to reply to that?
Sure. And not so much as a reply to Christina, who I will defer to her description of the European approach. For sure, it is sometimes raised, and I do think, I think Christina referred to as a caricature of the claim that Europe's not doing consumer welfare. I think that's right. They obviously are. And there are sometimes subtle differences in the way that we sort of weight different types of evidence or different types of theories. You will sometimes hear as part of that discussion, well, the U.S. approach only does price and output, and we somehow, sort of blinded to innovation cases. I don't think that's right either. I can think of a number of innovation cases, both in the merger context and the unilateral context, for sure, that the FTC has brought. So I don't think that there's anything in either approach to consumer welfare that would prohibit either set of institutions in the EU or US from going after cases that involve theories of harm to innovation. Again, I think there the differences are more methodological than conceptual. The proof is in the actual application of the concept to the evidence. What evidence substantiates some theory of harm? We all read the same math models, can sketch out a theory of dynamic foreclosure or harm to innovation or harm to an edge provider or whatever else. We sort of all can do the same models. I think the question is much more to do with what evidence is sufficient to substantiate those claims. And there I do think there is some difference. I think there is more reticence in the U.S., and we can talk about whether this is a good or bad thing, but some reticence to use models that are commonly invoked in the theoretical I.O. literature, but sort of less often substantiated with empirical evidence. I think there's more reluctance. I think there is certainly, and Nicola's comments to start with emphasize this, I think there is certainly more of a requirement in the U.S. to show actual effects and a little bit more of a suspicion over likelihood effects. That may be a function of judicial review in some places. It may not be. So that'll be sort of one big endogenous bundle. But I think the way to think about which of those approaches is superior almost has to get at outcomes, right? It has to get at trying to measure performance in the actual marketplace. And that is a place where I think the FTC's got some comparative advantage in trying to, these are really hard questions, and we all have our favorite cases or favorite examples of type 1 or type 2 error to tell, but I think these are really hard, thorny questions that require a lot more empirical evidence than they do theory.
Thanks, Josh. And I would just add to the evidence, the evidentiary standards are slightly different, and also the burdens with the agencies, where the burden lies. Burdens of proof. Nicola, you wanted to say something. I saw you.
Yeah, so I think there's probably not so much, support to the notion that you really need to bring a categorized theory of liability to fly an antitrust case in Europe. And actually, the decision of the European Commission is very long. It's 220 pages more. Shows that the defendant said, Google said, well, you've not shown me an essential facilities theory of liability. You've not shown me a sort of, duty to deal kind of story here, commission. So you have no case. And the commission said, and, rightly so on the basis of judicial precedents, the commission said, well, there's no a laundry list of theories of liability on which I have to rely once, pick one to run a case. This is open-ended. This is fluid. Abuse depends primarily on anti-competitive effects. So then question is, what Josh mentioned earlier, what kind of degree of nature of anti-competitive effects you can rely upon to bring Section 2, Article 102 case. And in Europe, the feeling seems to be, well, capable is enough, and uncertainty is less of an obstacle to antitrust enforcement.
Thank you, Nicola. We have some questions from the audience that I think are relevant, in particular for Nick, but others should feel free to weigh in. And one is, how serious of a consumer harm is it when the consumer simply has to download a different search engine? They have the benefit of pre-installed, and they can still choose a different one. So this is getting at some aspects of the Android case, obviously not the entire case, but a piece of it. So maybe, Nick, if you'd like to respond to that.
Sure.
And maybe I'll ask the other panelists to think a little bit about remedial challenges in some of these digital platform cases, and we can have a discussion about that.
Sure. Well, first of all, I should have said it from the beginning that I don't have any particular company or entity that I work for except NYU, and these are the only people who are paying me to do this research. Second thing I was going to say is that I said the word snookered about the FTC. I didn't say they were captured. That's something that I don't want to say. This is more onerous implications, which I don't want to get involved with, and I don't really believe it. Coming down to this question, I am old enough to remember exactly the same defense by Microsoft when there was the issue that Internet Explorer was inside Windows, and was that an advantage to Microsoft or not? Microsoft would say, look, it takes 1 minute to download Netscape, and anybody can download it. Whether it's as easy as people say, it's an empirical question, and I think, at least my feeling, maybe I'm too old for cell phones, but my feeling is that it's much harder to download a new browser on a cell phone than it was to download a new browser under Windows, or is under Windows. So it's an empirical question. I don't want to presume the full answer. This is something that anybody who brings a case and anybody who argues a case should really specifically look at. But even if the harm is small there is an issue of the consumer not having readily all the alternatives and ways in which companies with very large market share, over 90%, have written exclusive deals so that other browsers are not available, or other search possibilities are not available on cell phones.
Thanks so much. And actually, Simon wants to speak, but it's perfect because I had a question. As Nick was speaking, I was thinking about sort of the digital competence, the technical competence that we have within our agencies. I know the UK CMA is sort of making itself digitally fit for the new age. So as you comment on what Nick has said, if you could bring in a little bit about what your agency is doing in that respect.
Sure. Well, part of my reason for wanting to speak was so that I didn't have to answer the question of how exactly you remedy these issues, because I think it's a particularly difficult one, and inevitably will be something you have to decide on the facts of each case. Going to the original question about how easy or otherwise it is to download apps, I think there is research that suggests that the only area in which Bing has a significantly higher share than Google search is on Windows phones, where it is pre-installed. And so going to Nick's point about the empirics, I think you can, even if we all say it's quite easy to do, even small amounts of friction, I think, can be shown to really have quite a large impact on consumer behavior, particularly when you extrapolate it and multiply it across the millions of devices sold and the millions of interactions that we have with these devices. So that's that point. I think Maria was asking about sort of digital expertise. I think this is a key issue. It was alluded to earlier about the sort of information asymmetry that exists between regulators and tech companies, and one of inherently, because all these cases are so fact specific, you really have to get into the weeds of the case, and that requires us to really understand how these markets work. And taking our inspiration in some ways from the FTC, actually, in their Office of Technology, we've recently appointed a sort of head of digital and are forming a data and technology and analytics team, which will be a sort of mix of not just the sort of usual lawyers and economists that populate antitrust authorities, but also data scientists, analysts, and the like. And so really trying to understand what the implications are of data, how we can use that data ourselves, how we can better assess it, and then also looking at how one might use data. And this I think is an interesting question, perhaps to which to come back to in future hearings, is how we can use data actually to drive better competition in markets.
Well, that's the topic of our November hearing. So, in case you want to come back to Washington. I don't know if others want to comment on the remedial challenges or whether we want to turn to regulation. I have a question from the audience, and I know we've had a few rounds of emails about regulation. And so, anyone want to comment on remedial challenges, or should we move to regulation? Okay. So the question from the audience was, do you need sort of an identifiable market failure in order to regulate ex-ante regulation, and what are sort of the costs and benefits as compared to case-by-case enforcement? And I think hopefully panelists will address that question, but also more broadly, what are the competition harms that we're worried about that can't be addressed by antitrust enforcement actions, and what would that regulation look like? Does anyone want to start?
I can do the first one, yes. Yes, you need a market failure to have ex-ante regulation. I'll let my co-panelists do the heavy lifting on the rest.
Might have been one of your students that submitted the question.
I would pay them for harder questions. Don't do it, guys.
Yeah.
I might say that I agree with George. I mean, this is, when we're talking about sector-specific regulation, we really need to prove that antitrust doesn't work. And there is some sort of what we usually economists call market failure. One of the areas in which it seems that there is a market failure and antitrust cannot fix the problem is in the collection of data by companies such as Facebook or Google or others without payment. So usually you would expect when some exchange happens that there is actually a price, but here the price has been set to zero. So in my book, that counts as a market failure, and there we need to think seriously about how to regulate that market, and even create the possibility of a real market there in which money changes hands.
Thanks very much. Christina?
I'm happy to jump in. Well, I would like, again, to give a sense for what is the broader debate which is taking place in Europe now. I think the question of whether we need to default to regulation or think about regulation in the event that we decide that the antitrust tool is insufficient, I think is not quite well put. I think in Europe the debate at the moment is very broad and very live about how we need to think in a holistic sense about all of these tools, and not necessarily think about them sequentially or separately. The initial discussion was, of course, like everywhere, do we have the right tool in antitrust, and how should we somewhat sharpen them? adapt them in this new world. And the standard answer that you got until fairly recently was, we just have the tools. We have all the tools, we just need to apply them properly. And don't lose your head, there's nothing to see. And I think that kind of certainty has become quite shaken by the notion that we observe phenomena, as I mentioned earlier, that we are questioning. Why don't we see this kind of seamless world of overtaking and leapfrogging, and why don't we see these kind of phenomena sort of out there? So there is a sense that a broader approach is needed, and this is not sort of a populist extremist fringe that takes this view. This is kind of mainstream at the moment in Europe. Even Jean Tirole, just to mention someone whose credentials are obvious, at Nobel Prize, has been talking about the necessity to rethink a bit the approach in these cases. He's talking about participative antitrust. There's a potential way to think about it, so no longer sort of a prosecutorial, but a way in which perhaps companies could sit together, or can come together in addressing some of the issues. There are bodies of very respected orthodox academics in Europe, economists and lawyers, thinking about how indeed the tool needs to be significantly updated. In Germany, you have this next level antitrust paper. You may or may not agree, but this is very influential in the way we think about it. There is the group of people advising the commissioner saying we need to just be less insular in the way we think about antitrust, because we are kind of constantly thinking about, do we have the tools, can we sharpen them a little bit? And we need stock taking of what the issues are, and then thinking again about what the best tools are. Now, and then of course, as you mentioned, there is, in fact, an additional point, the UK Treasury has launched a digital platform initiative just to, again, try to identify the questions before we rethink about the use of the tools. So I think there's the initiative on regulation is trundling through the European Parliament. There are various regulatory initiatives at the national level. And I think that is certainly going to go ahead. It's going to fill any vacuum that antitrust enforcement leaves. One of the models that you hear people talking about is, well, we've been dealing with telecoms company in the past. We've adopted an end-to-end interconnectivity approach in which we mandated number portability, we mandated all sorts of access regimes, and that's what we've done. Why can't we find the equivalent in this world? I think this is more than a question of detail, it's very important. But just to say that I think that discussion about the instrument mix is super live in Europe, and it isn't just about fiddling at the edges with antitrust. It is a broader and more ambitious sort of view.
It's interesting to think about why some of the discussions in Europe are different from those here, and whether there's kind of a more openness to regulation. The discussion about different tools had me thinking a little bit about the UK's power in their sector inquiries. Do you want to weigh in on that at all? What that might look like for digital platforms, or how your experience might inform this kind of multidisciplinary approach?
Yeah, sure. So, I mean, we in the UK have the benefits of sectoral market study powers that not only allow us to look across a sector as a whole where the market may not be functioning well, but also at the end of it allows us to impose remedies, orders that sort of quasi-regulatory remedies. And I think in this sort of circumstance, that can be a very powerful tool. Both Nick and Josh talked about the need for a market failure. I mean, I agree, and a markets tool, I think, can achieve that. It's a 2-year investigation that really looks to understand how the market is operating, what are the factors that are driving the assessment, the way in which competition is operating. And that allows you to look at competition issues, it allows you to look at consumer issues, and then not have to try and shoehorn things in through the very tight antitrust lens. One might see it in a recent banking study we looked at, where previous attempts to sort of make switching easier and the like hadn't necessarily worked. So we looked at the market again, and actually have there introduced a remedy which brought forward what's known as open banking, which is about allowing people to port their data, from their financial data from one bank to another, and engender competition that way. So I think it allows you to really take this detailed look at a market based on the evidence to address it, and thereby put in regulation that's really sort of tailored to exactly the harms you're trying to get at.
Thanks, Simon. You know, the discussion we had earlier on intra versus inter-platform, I was thinking about the question a little bit from a slightly different perspective. And that is, should we in the US be more concerned about intra-platform competition? I keep hearing saying, well, Europe is concerned about inter-platform, but I guess there's a different question, which is the US sufficiently, do we pay sufficient attention to intra-platform competition? Does anyone want to take that on? Yeah.
So, yeah, just to come back on, the previous points which have been made about what agencies should do in situations of uncertainty, I think what they should do is, have a set of first principles to think about uncertain markets. And I think one of those first principles is to say, well, we're going to go to these markets if we see there is not enough inter-platform competition. We're going to look into intra-platform competition. Sort of, kind of reasoning that we've had in vertical restraints, in Europe at least, for a long time. And so your analysis of intra-platform competition becomes important, and the scrutiny becomes important if you feel that a market doesn't have sufficient degree of inter-platform competition. And on that, it's often sort of, difficult to make that preliminary assessments because the question is, what is the platform you're talking about? So, for instance, if you take the Google Android case, you could say, well, the platform is search, and there's not enough competition because Google has between 90 and 100% market share. But at the same time, you can only come to that reasoning if you've excluded from your analysis Apple and its closed ecosystem from the analysis. And you could say, Apple's siloed ecosystem is also a platform which competes with the platform of Google, which is search plus Android. So it is the first question to ask. It's not an easy question. Sometimes I think the tool of antitrust, like market depth, can be misleading in that assessment.
Well, I was going to say that, an interesting issue of intra-platform competition could arise in the distribution of the distribution that is now dominated by Amazon, when you have some sellers that are selling it directly to consumers and also selling through Amazon. So there is at least the possibility of anti-competitive effects in intra-platform competition. But again, I haven't studied this, so I'm just discussing a possibility of a platform where this might be looked at.
Thank you. We've got a couple of questions here from the audience, and I'm also conscious that the time is ticking and we're at the end of the day. So I'm going to ask both the questions at the same time, and when you think about your responses, also feel free to respond to the questions that have just been posed prior to this. So one of them is essentially, even if there's not specific cases, are we seeing, at least in terms of rhetoric, a return to an order liberal or structural approach to antitrust in Europe? Christina is raising her eyebrow, so I have a feeling she may go first on that. And the other one is the panelists have been asked to look 10 years ahead and consider emerging technology. So algorithm AI, big data, et cetera, et cetera. Can you comment on these new theories of harm on the US and the EU and the outlook for these? And I suppose thinking in particular about platforms. That's quite a tall order, so Hopefully, a couple of you can rise to the occasion, but I understand if not everybody wants to. So Christina, do you want to mention anything on the order liberal?
I feel called to respond to this. Well, look, I mean, of course, there has been a history in Europe in which the sort of traditional German order liberal position has been, in effect, looked at as somewhat of an oddity, in the sense that the drive towards adoption of consumer welfare, which has been overwhelming across all other jurisdictions, has been the prevailing one. And in all of this, the German position, although it has been influential in shaping competition law in Europe in its beginnings, has inevitably had lost a little bit of traction, and indeed was not center stage. At this point, there are voices that say, in this discussion in which we're worrying about these large, giant companies, is it the case that we are seeing the order liberal position kind of rearing its head again? Well, I suppose if you're in Germany, you can feel quite vindicated by that discussion, and take the view that somehow the investigation of Facebook is not something that is so eccentric after all. I think that the more sober sort of way of thinking about it is that we worry about a number of things. And size is one of them, because it's not size per se, but it is the fact that we don't see, once size has been achieved, a great deal of dynamism in the sense of challenging perhaps that kind of large established position. And it's going back to what I was saying earlier. There is no sense that there is at the moment any leapfrogging likely, or any sort of change in that sort of in that market structure that's before us. So it's that which is that a sort of an order liberal principle? No, is that we are worried about what we see, size, and the fact that there is clearly a limited number of large players controlling attention in very limited channels, raises question that we need to address. It's not a return to order liberalism. I think it's just the questions we need to address.
Well, I've just had another question come in that's probably slightly more nuanced. If you have the structural order liberal approach here, and then you have the effects here, the question is that the panelists, both this panel, previous panel, have sort of observed that European enforcers might be more willing to, or more comfortable basing enforcement on likely effects. I mean, certainly the case law allows them to, and they may have greater comfort level doing that. Whereas in the US, typically we focus on actual effects. And the question is, which approach is better for digital platforms? Would anyone like to comment on that, Nicola?
Yeah, so again, on first principles, I think there's no reason to exclude, as a principle, the ability for the agency to advance on a capability or likely effects theory. But if you do that, you need to, so the first principle is you need to provide symmetry to the defendant. And so you need to, so if you're in the game where you're saying the effects are uncertain, but we go for it, and this is probabilistic, as was said before, well, then you should allow the defendant to also say that there is competition, but it's probabilistic, so it's going to hit somewhere, right? We heard before, people say, well, it's all make-believe, that, those guys say they have competitors, but we don't know them. Well, maybe it's not. I mean, Schumpeter has written about that, competition felt, the intensity of competition that you can't locate in the markets, but it might be there somewhere. And so I think when we think about likely effects, we also need to provide the defendants symmetry to advance probabilistic competition as a defense.
Thank you. Simon, I'll ask you to weigh in, and then I think starting at the end with Josh, I'll ask everybody to give their closing remarks in addressing that 10 years ahead question, if possible. Go ahead, Simon.
Very good. Well, I will combine your third question and the 10 years ahead one, and so this can be my closing as necessary. But I sort of think of this through the mergers lens as an interesting way of looking at it, and I caveat this with the statement that I consider it a success to have made it to the end of the day. So looking 10 years ahead, I find quite difficult. But sort of that aside, I think I don't think when we're looking at, say, a merger of involving the acquisition of a startup, I know there's going to be a lot of discussion about that tomorrow, inevitably there is going to be a degree of uncertainty as to what the future might hold, both with and absent the merger. And I do wonder whether sort of over time we have worried too much about over-enforcement, particularly if you have a number of potential theories of harm, each of which is relatively low likelihood, but the likelihood of one of them happening is rather higher, and if it does, it's a very significant effect. And I think the other thing about mergers, and it goes to the second question about looking 10 years ahead, is that we see two aspects. One is the what was described yesterday as horizontal expansion. So this is sort of really the stretching out of the platforms into new markets. There's a lot of talk about fintech at the moment and how we can see the traditional banks using new technology. Well, one can equally switch it around to tech fin and see how it's the traditional tech companies suddenly seeing that there's a potential financial services market. And the other element of that, I think, is when you look at where is the innovation happening, and when you have increasingly sort of the centers of innovation, the innovation poles all being located within a smaller and smaller number of companies, then I think you do have to wonder how the sort of Schumpeterian competition, or whatever you want to call it, where in fact that's going to come from.
Thank you.
On the,
Josh? We'll just go down the table.
I'll go quick. I'm frankly not totally positive this will answer the question, but it's the thing I want to say at the end, so I'm going to say it. I think the principles in getting into these cases where we kind of test the limits of our predictive powers at the agency, whether that's 2 years, 5 years, 10 years, or what have you, there are a couple of different ways to approach that conceptually. And one is we could stack theories of harm and sort of add up the probabilities, but the defendant's got theories of efficiencies too, and if we stack them, we have 2 events with the probability of 1, and that's hard math. So I think the better approach is when we don't know, when we have these theories and we sort of don't know, and we find ourselves with big confidence intervals around our guesses. One thing that the agency, and I think the FTC is uniquely situated to do, is to try to participate in competition policy R&D. Go out and identify important questions. There's a bunch of young IO and labor economists around the world who need stuff to work on, and these are important questions where the theory to empiric ratio is like infinite. And I think that means there's sort of fun, important work to do, and people ought to do it, and I think the FTC or competition agencies around the world identifying it as an important area is a really important thing that those agencies can do.
I hear a lot of Bill Kovacic in those remarks, and I applaud them. Okay.
Can I say something
Sure.
about the 10-year prediction? After all, it's the end, so might as well make a prediction. I think that if you look at platforms, you have to look at sectors that have stayed behind and they're the most likely to convert to platforms. And these are the health sector, banks, payment systems, part of the banking world, and currencies. So within 10 years, I'm pretty sure that all these are going to become platforms, are going to be transformed by platforms, and the companies that will not be able to get in, to transform themselves, are going to have a very hard time. Let me say one last thing about it, and that is probably the most sure thing I am, is that the labor share of GDP is going to become smaller because platforms use less labor. So this is important. It's going to show up again and again. It's going to show up first in the United States because platforms are very, very important here. And we have to think of ways to, we have to think of the social consequence of this and ways to alleviate it. Thank you.
Thank you. Nicolas?
Yeah, so 10 years from now, what we're going to see, I don't know. What I'm seeing today is mushrooming of new theories of liability, like copycat innovation or acquisition for infanticide, also called the Kronos effects by some, after the Greek Titan who had this oracle prediction that he would be killed by his son, so he basically ate all his sons. We are reading those claims in essays, newspapers. The press is an abundant purveyor of the series. And, like Josh said, I think all that is science fiction for now. We'd like to probably promote some computational R&D in that space and try to understand a little better before we jump into the sort of Nostradamus predictions that the press advances. You know that all too well. I mean, good news don't sell, so why not throw there some series of liability and harm and just get away with it. So I think we need to put economists and data scientists in a room and ask them to look into that seriously.
Thank you very much. Christina.
Well, we're out of time, so I will not hazard any predictions on the next 10 years. I'll just say a couple of words on one of the last questions that was put, this notion again, which is coming up from the audience, that somehow, and I accept it is a characterization that's popular, the US looks at actual effects and we in Europe somehow speculate. And that is something which I find a little bit, again, a caricature. Relative to, for example, the panel we had earlier, if you think about very much what was discussed on the panel, a very clear discussion about Doug Melamed, Susan Creighton, very clear that what was at stake at the time was a prediction that effectively the conduct that was being looked at was going to, in prospective terms, in probabilistic terms, be likely to undermine innovation, which is what we care about. So exactly why are we not seeing that the sort of analysis has got to have some element of probabilistic view that more competition tends to mean more innovation? I don't think it's eccentric. So I would just invite that as a reflection and indeed end up on what I think is something we can all agree on, which is Bill Kovacic's invitation to do more R&D in this space is absolutely the best way to end.
Thank you, Christina, and thank you to all of the panelists, a number of whom came from very, very far to participate in these hearings. We are enormously grateful. Having your participation in person is so meaningful. So thank you very much, and if all of you would join me in thanking the panelists.